It is time for Legal Talk on eRadio every Wednesday morning at 10 o'clock. And today we are joined by Wynand Pieterse of Hahn and Hahn Attorneys. He's also an associate attorney at Hahn and Hahn, and a very interesting topic, as always, talking about choosing the right options when starting a business or when your business starts to grow. It's very, very important to make sure you dot those I's and cross those T's, because believe me, when your business starts growing and your things aren't in order, you will certainly know it. But we're talking to Wynand. Wynand, a very big hello to you. How's it going?
Good on you, Ian. No, it's going very well on my side. I hope the same there on your side as well.
Very good, thank you. Nice to talk to you for the very first time, and I'm sure it won't be the last. Wynand, you're an associate attorney at Hahn and Hahn. How long have you been with the firm?
I'm currently have been with the firm for the end of this year will be 4 years. So I did my articles with the firm, and now I'm doing my post article with them as well, as an associate attorney, as you already mentioned.
Okay, and is there anything that you specialize in at the firm?
I would say generally I do all types of matters, but I have quite an interest in corporate and commercial related matters that come our way, hence the topic of today as well.
Yeah, that's why you're the guy to talk to today regarding this topic. So I think let's start off with this question. Why is it important to consider your options when starting out or growing your business?
Well, Ian, to start off with, it is very important that one deliberates on the type of business to be formed and incorporated when starting a business, and what business or company structure would work best in the long term, which will ultimately then result in the best business growth. So there are different options available to a person when starting or growing a business or a company. Therefore, careful consideration must always be given to basic company concepts and all company documents that must be in place from the onset. So this will just make the job, so to speak, easier when you start off your business.
Yeah, that makes sense. And what company structure do you choose when you're starting your own business? I mean, it probably depends on how many people you've got and what you want to do.
Yes, no, definitely. So the Companies Act makes provisions for two broad categories of companies that may be formed and incorporated. These being profit companies, which there are 4 different types, which I'll elaborate a bit later on. And then you get your non-profit companies. So firstly, when we talk about a non-profit company, it is formed for some sort of public benefit or objective.
That's an NPO.
Or any other objective pertaining to a social or cultural activity or group interest.
Mm-hmm.
So what sets this type of company apart from that of profit companies is that the income and property of the non-profit company cannot be distributed to its directors or members. So all the profit that is made must be plowed back into the company per se. So these types of companies are subject to a slight modification of the Companies Act, as the Companies Act obviously applies into profit companies, and the Act clearly states which specified parts must be considered and what distinctive set of rules find application on this type of company. So on the other hand, when we talk about profit companies, these are formed for the main purpose of financial gain for its shareholders. So profit companies then can be subdivided into 4 categories, being then the private company, a public company, the personal liability company, and the state-owned company. So for purposes of our discussion today, I think I'm mainly just going to focus on the private company and the public company and elaborate a bit on that aspects.
Okay.
So there are a few characteristics that are common to all profit companies when one wants to consider whether to incorporate a company as such. These being, firstly, as mentioned, the main difference between profit companies and non-profit companies is that profit companies' purpose of incorporation is the financial gain for its shareholders. Furthermore, a profit company is formed by one or more persons, being its incorporators, regardless of the type of profit company. This is in contrast with a non-profit company, because when a non-profit company is incorporated or formed, it requires a minimum of 3 incorporators, let's say persons then, acting together to form this non-profit company. And then lastly, a profit company can have any number of shareholders. So there's no limit on the number of shareholders that can be in a profit company, and what makes a shareholder will be elaborated later on as well.
Now, Wynand, when we talk about a separate legal personality when it comes to companies, what is it?
So what this essentially means is that from the date and time that the incorporation of a company is registered, the company has all the legal powers and capacity of an individual, obviously except to the extent that the juristic person, being the company itself, is incapable of exercising any such power or having any such capacity. A company's Memorandum of Incorporation can also provide otherwise in relation to these specific company powers. Thus, it's simply meaning that a company is its own juristic person acting through agents, normally being the board of directors of the company. As a result, a company can be sued in its own name. The assets bought in the company's name is the company's assets. Furthermore, all profits generated by the operation of the company belongs to the company, and any debt incurred by the company is furthermore that of the company. Therefore, the person responsible for the running of the company, like the directors, cannot generally be held personally liable towards actions of the company. However, there are certain instances where this can be the case, for when, like, the directors misuse the company structure to avoid liability, or in certain circumstances as outlined specifically in the Companies Act.
Okay, so now let's talk about the difference between a private company and a public company, just to elaborate a bit. We'll start off with a private company. What is meant when we talk about a private company?
So when we talk about a private company, we firstly mean that it is a profit company, as we just said, and it is not a state-owned company. And its Memorandum of Incorporation will set out 2 provisions, which will state, 1, it prohibits to offer any of the private company's shares to the general public, and secondly, it restricts the transferability of its shares. So therefore, the 2 core characteristics of a private company are that its shares may not be offered to the public, and the transferability of its shares must be restricted. When we say transferability, we mean, for example, the selling of one's shares to another person or a company. The manner of restriction, one's ability to freely sell one's shares to any third-party public, can be imposed in various manners. These being the right of preemption, which essentially entails that if you are a shareholder in a private company and you wish to sell your shares to a non-shareholder or a third party, you will first need to offer your shares to the remaining shareholders of the company for buying. Another restriction can be, for instance, that one can only sell your shares to a non-shareholder of the company with the approval of the company's board of directors. And lastly, last restriction is that you can only sell your shares, let's say for instance, if it's subject to the approval of the other shareholders of the company. And then a last thing to mention on this, what constitutes a private company, is that a private company's name always ends with Pty Limited, which stands for Propriety Limited. And then lastly, a private company can only have one director, but may have more directors dependent on what the company's Memorandum of Incorporation states.
Okay, we've all seen those Pty Limiteds. I think, in fact, eRadio is also Pty Limited, so that is a private company. What is meant when we talk about a public company?
So when we talk about a public company, it is quite interesting that the Companies Act does not necessarily define what is meant by a public company. The Act merely states that a public company is a profit company that is not a state-owned company, nor a private company, nor a personal liability company. Therefore, by default, then, a public company is a company that is not any other type of profit company. So, when we compare a public company to that of a private company, the shares of a public company may be freely offered to the public. This results in a public company being able to raise capital from the general public at large. Therefore, shareholders in a public company may freely transfer or sell their shares to any member of the public, obviously unless the company's Memorandum of Incorporation imposes some sort of restriction. And then the further characteristics of a public company is that its name must end with Ltd, which stands for Limited. And the board of directors of a public company must consist of at least 3 directors instead of at least 1 in a private company.
Okay, now let's get technical. What is the Memorandum of Incorporation of a company? What on earth is that?
So when we talk about the Memorandum of Incorporation of a company, or MOI for short, as we would love to refer to it as that, we refer to the founding document of the company. So the MOI is the sole governing document of the company, by stating that it sets out the rights, the responsibilities and duties of directors, shareholders, and other individuals within and in relation to the company, together with various other matters that may impose on the company itself. Therefore, the contents of the MOI deals with matters such as the powers of the directors, the ability to create rules of the company, shareholders' meetings and procedures, and the composition of the board of directors in general. Then furthermore, when we consider the MOI, the Act imposes certain core or mandatory requirements that must form part of every company's Memorandum of Incorporation. There are certain unalterable provisions in the Companies Act which cannot be changed by the MOI. These provisions cannot ever be made more onerous by imposing stricter requirements to be met than what is set out in the Act itself. Then furthermore, each provision contained in an MOI must be consistent with the Companies Act and cannot go against it. There are ever certain rules, provisions contained in the Act that a company may choose to accept or alter in its own personal MOI. This allows for flexibility to a company's Memorandum of Incorporation. So then, Ian, in conclusion, Memorandum of Incorporation can therefore either be in the prescribed form by adopting the mandatory provisions of the Act and accept the default provisions, or a company's MOI can be so drafted to be unique to the company itself by incorporating additional provisions or altering the default position.
Okay, well, that's an interesting explanation there. Sorry, I'm just trying to process all the information. Okay, Wynand, now you get shareholders and you get directors. What is the difference?
Yeah, so this is quite an interesting part of the Companies Act. We see it quite often when clients come to us and then they don't completely understand the difference between a shareholder and a director of a company. So I hope with this we can give a bit of clarity on that. So the Act defines a shareholder as a holder of a share issued by the company and who is entered as such in the certificated or uncertificated securities register. So a certificated or uncertificated merely means when a share is issued, it can either be certificated, meaning there's a certificate showing that you owe a certain percentage of shares in the company, or uncertificated, meaning there is no such certificate issued to you, evidencing the ownership of that share. So a securities register or share register is then a register that every profit company should have, which will detail who is the current holders or owners of the issued shares of the company, and detailing the history of the transfer of all the shares prior to you acquiring that specific shareholding. When we talk about issued shares, it means shares that has been bought by some individuals or companies, and we talk about issued shares and authorized shares. So when shares are authorized, it means that the company, for argument's sake, may have authorized 100 shares to be issued, and currently, let's say there are 50 shares that has been issued and 50 shares are still being held by the company. So then it is further important to look at what is a share when we talk about a shareholder owning a share in a company. So the proprietary interest that a person holds in a company is a share. A share is therefore considered as a fractional part of the whole share capital in the company. It confers upon the holder, in other words, the shareholder, the owner of the share, certain rights to a proportionate part of the assets of the company, whether by way of a dividend or the distribution of assets when the company should be wound up in future. Shares is further divided into different classes, each with their own rights attached. So then, a shareholder, in simple terms, is thus considered to be one of many owners of the company and can exercise their rights dependent on how many shares an individual shareholder holds in that company. Shareholders, through a resolution, give their consent to the company to adhere to certain decisions and actions that needs to be taken by the company itself. On the other hand, when we talk about directors, directors are tasked to adhere to the day-to-day running and management of the company. So there is thus strict compliance placed on each and every director forming the board of directors when in this position. So the Act and the common law places certain duties, which we refer to fiduciary duties, on directors when they manage the company on a day-to-day basis. The directors in turn only owe these duties to the company itself and to no one else. So this can, if these fiduciary duties are obviously transgressed or contravened, the director can be held personally liable for this transgression and can subsequently be removed as a director and not be able to serve on any company's board of directors ever again or for a certain period.
Okay, now, Wynand, last question. A shareholders agreement, is it necessary? I would imagine yes.
Yes, the short answer is yes. It will be beneficial to have a shareholders agreement in place. It is, however, not strictly necessary to have such an agreement in place, and it's not required by law. So a shareholders agreement, in short, is an agreement that is drawn up that governs the relationship between the shareholders of a company and with the company itself, setting out the responsibilities and powers. This agreement clearly states the provisions that will apply when it comes to the transferability or selling of one shares to another, and the restrictions that will apply in the case of private companies, as previously mentioned. Furthermore, the shareholders agreement must at all times remain in line with what is stated in the company's MLI and the Act, and may not contradict one another. A shareholders agreement can be entered into at any time should the need arise, therefore. So to consider whether a shareholders agreement should be drafted will be a very case-specific thing, dependent on the type of company, its prospects of growth, and the shareholders' general needs. The shareholders agreement should thus be drafted in such a way to fit the objectives of the specific company. It will obviously be advantageous to have this agreement in place when the time arise when one shareholder wishes to sell his or her shares, as the agreement will clearly state the provisions that will apply. A shareholders agreement is a private document as well, and it is not filed with the company's commission or open for inspection by the general public. Furthermore, a shareholders agreement is binding on all the shareholders to it, and the normal principles of the law of contract will apply, because it will be like a contract that you enter into with someone else, and then the normal laws of contract will apply to that. One disadvantage that I can just highlight when it comes to shareholders agreement is that it only binds those shareholders who are party to it. So let's say it will further not bind any new shareholder to the company unless they consent to be bound by the agreement and sign the agreement, or if the shareholders agreement is amended by the inclusion of this new shareholder to the company itself.
Yeah, that makes sense. Wynand, wow, this is a very interesting topic, and you know what? I think we've only scratched the surface, because I think we need to do a follow-up, because imagine if these things start going wrong. We need to talk about that in a future talk. When things go wrong definitely. In a company, I mean, that can get very hairy, a hairy situation. I'm sure you've dealt with these cases as well, where partners are now accusing each other of things, or money goes missing, or papers go missing. think, oh man, the list is endless. It can go really wrong if you enter into a partnership as well. So I think we'll talk about more of that in the future for when things go south. What do you say?
Yes, no, definitely. I think that will also be a very interesting topic to talk about.
Definitely. Thank you, Wynand, for your time today. Just in conclusion, how do we get in touch with you?
You can definitely, I can be in contact by my email address, wynand@hahnlaw.co.za, and then phoning the office as well and to inquire about anything that may be necessary.
Okay, and that's 012-431-2480. You can also visit the website hahnlaw.co.za, and that's HAHN. That was Wynand Pieterse, Associate Attorney. Thank you so much for your time today, and looking forward to the next one.
Thanks so much, Ian. Have a nice day further.
Are you or your business in trouble and struggling to find a solution? Call Hahn and Hahn Attorneys as we assist clients in finding solutions. We specialize in consumer and food law, commercial and construction law, forensic investigations, and administrative law. Visit hahnlaw.co.za. That's HAHN. We assist clients nationwide. Hahn and Hahn Attorneys, because we care. Don't miss Legal Talk with Hahn and Hahn Attorneys, Wednesday mornings at 10 on eRadio.